Criminal Passage 17 start. Learned counsel for the appellant argued that incident is nocturnal and complainant has not disclosed about any source of light on the spot. That's why the occurrence has been reported with considerable delay after consultation and deliberation, and the appellant has been charged on mere suspicions that the motive alleged remained unproved, that alleged eyewitnesses, that is, complainant and prosecution witness, are closely related, being his cousins, therefore are interested witnesses who have badly failed to establish their presence on the spot. That's why their testimony is neither consistent with each other on material aspects of the incident, nor does it find corroboration from other circumstances of the case to inspire confidence. Therefore, conviction cannot be recorded on the basis of such shaky and scanty evidence. That escape or let of the complainant and PW, being closely related to the deceased and at the mercy of the appellant in close proximity, is a disturbing circumstance which creates doubt in a prudent mind. That medical evidence also belies the ocular account that deceased was a hardened and desperate criminal and was done to death while committing offense wearing a burqa, and the factum of wearing burqa has also been admitted by the complainant in his statement that the crime empties have not been sent to the forensic science laboratory for chemical analysis, that appellant has neither confessed his guilt before an incompetent court of law nor anything incriminate has been recovered from his direct or indirect possession, nor has made any discovery that investigation in the case has been conducted dishonestly, as the appellant was already arrested in a case FIR number 185 dated 15/5/2010 registered under sections 324-353 PPC, read with 5 Explosive Substance Act and 780A, as well as 13 AO Police Station Mathani, but this factum has deliberately and intentionally not brought by the investigating officer on record of the instant case, which amounts suppression of facts. That prosecution case is pregnant of doubts, benefit of which was to be extended to the appellant, but the London trial court, by not appreciating the evidence in its true perspective, reached to an erroneous conclusion by holding the appellant guilty of the offence. Hence, the impugned judgment is liable to be set at naught. Conversely, learned counsel for the complainant contended that appellant is directly and singularly charged for murder of the deceased by the eyewitnesses, that during spot inspection, besides recovery of blood-stained earth and crime empties of 7.62 bore, the IO investigation officer has also recovered 200-watt electric bulb. Hence, question of mistaken identity does not arise. That, keeping in view the time of occurrence and the place of incident, a backward area of Mathani at a considerable distance from the police station Mathani, the non-availability of transport because of the law and order situation in that particular area, delay in lodging report is not fatal for the prosecution case, that both the eyewitnesses have furnished true account of the incident corroborated by medical as well as circumstantial evidence, and the defense has failed to create any dent in their testimony, that it was quite easy for the eyewitnesses to also charge the appellant for attempting at their lives, but they did not, and narrated what they witnessed, which manifests their truthfulness. That admission of complainant about wearing of burqa by the deceased at the time of incident in his cross examination. Full stop and close.